First thing is you need to understand that a credit reporting agency is unable to maintain accuracy to the degree that you need it to be accurate. Sorry. To the degree that you need it to be accurate. Okay, and um, because of this, you end up suffering, your credit score suffers. Um, so I'm gonna bring out this dispute template, and we're gonna go through this, and I'm gonna break it down, what's happening, why it's happening, and so that you can get a move on things. Okay? So let's first address the Fair Credit Reporting Act and how we as Pwashanan address credit. It is the Fair Credit Reporting Act. And so it is the fairness that promotes the inaccuracy. Well, what is considered unfair? Unfair is if you have demonstrable harm. And if paying a debt is going to put you in a disparate situation, then that is a cause for what we consider to be equitable. So our legal principle stems on acknowledgement of the true situation so that we can leverage either laws, statutory laws, or laws of equity. Okay, laws of equity are put in place when standard execution of the law does not lend to a good outcome for the person. So a judge may offer equity in the form of an eviction stay because putting you on the curve might create undue hardship. You might not have the finances to move. Okay. And in some cases, they may award it financial relief in some cases, depending on how it's framed. So this is a template that will be available on pwashana.org. I'll put the link in the bio so you can just go to the website, download this form, this document, and we're going to read through it together so that you understand part one. Okay. So you get your credit report through one of the major bureaus, and the reason that you are disputing or addressing it is not to avoid paying a debt. It is not to evade any type of responsibility. The purpose of addressing your credit is because you want to steward your finances in a way that aligns with your life and has a long outlook. Okay. And once you understand this about credit, then you'll begin to understand the nature of how you should behave in relation to it. All right, so the first thing we're going to address is the consumer credit dispute. And the purpose of that is to adjust your credit report so that you can get approved for a house or a car. Okay? At no point should your credit not allow you to get approved for something. It doesn't matter if you just had something happen. Why didn't you pay it? Well, the reason you didn't pay it is because you don't have the money. The longer you take to explain that to the debt collector, the longer you're not going to be able to have money. So even if you have good credit, the most beneficial thing you can do for your finances is to ensure zero inaccuracies. Otherwise, it's costing you somewhere. Okay, that's literally how important the credit report is. All right. So you get your credit report through annualcreditreport.com. It's free, and the government offers one per week. Okay. Now, if you want a more streamlined approach using Experian.com or Equifax.com, these are the primary bureaus, TransUnion. That's no problem either. They may ask you to pay a small fee for their service because essentially what they are doing is reporting what they're pulling from your LexisNexis. So they're not even the primary holder of the data in some cases. Okay. So here we go. Consumer credit dispute. Pursuant to the Fair Credit Reporting Act, 15 U.S.C. Section 1681, which is the entire Fair Credit Reporting Act. Okay. 15 U.S.C. Section 1681 is the Fair Credit Reporting Act. Okay. Your full legal name, you'll type your name there, your date of birth, your current address, and if you go and look on your report, you'll see a dispute or a credit report number. Okay. You'll put your date there. Once you put your date there, to whom it may concern, I am writing to formally dispute the accuracy, completeness, and legality, key word, of certain information appearing on my consumer credit report. Pursuant to 15 U.S.C. Section 1681, Section I of the Fair Credit Reporting Act, this letter constitutes a request for reinvestigation of the accounts identified on Table 1.1 accounts. The information is disputed in its entirety. Okay, this means the whole account, not a part of it. Basis of dispute. The reporting of the above referenced accounts is disputed for the following reasons. 1, I do not acknowledge the accounts as accurate or legitimate. The information is incomplete and lacks proper verification. Continued reporting is causing demonstrable harm, consumer harm. And really that word is demonstrable consumer harm. The account is presently disputed and requires reinvestigation. So these are all facts. Okay, if you do not acknowledge it as an accurate or legitimate item, then it's automatically up for debate because you are the one who's in control of your credit report. So nothing can stand on your report as fact ever. You always have the ability to dispute it and make it to where it's up for dispute. It's not accurate. The consumer says this information is not accurate. That has weight. Taking action shows performance. Non-action is the reason the score is what it is. Non-action or a low score is the result of negligence or misinformation. Okay? So, a sworn declaration and affidavit executed under penalty of perjury is enclosed as Exhibit A and incorporated herein by reference. Okay, so we attach a sworn declaration to this document. We'll read through that next. Requested action. In accordance with your duties under the Fair Credit Reporting Act, you are required to, 1, conduct a reasonable investigation of the disputed account. So they're required to investigate this reasonably, not an automatic dispute. Okay, if you get results back and they just disputed it automatically, well, they violated the first requested action. Now, you have to understand how businesses work. They have to work in your favor, even if they're saying they're not. So ignore what they're saying and look at what they're doing. Okay, they can have all the laws all day. Okay, part of their revenue share is payable damages. That's why they have attorneys, because they know these contracts are in violation. And if you just happen to sue, well, we've cleared our conscience because the law affords you the ability to address us with these grievances through the CFPB, and we will happily pay the damages and continue doing business. All right. So, conduct a reasonable reinvestigation of the disputed accounts. They didn't do that? Well, then guess what? Delete it. Notify the furnishers of this dispute and provide them with my sworn statement. Well, guess what happens if they don't do that? Delete it. Require the furnisher to substantiate the accuracy and completeness of the information. Well, the burden of proof is very low for credit furnisher. So you have to understand that when you send out a dispute, most likely you're going to get a verified response. But the verification in such a short time is the trigger for the follow-up. And this is how they're safeguarding their process to make sure that you're not using AI or using some automated system to do this. It's very hands-on for the purpose of protecting the integrity of the results. They're in contract violation automatically if it's causing you any type of harm, any type of reputational damage, any type of emotional stress. These are not things that the human angel is designed to absorb. So, Pwashana, we have a recourse. All right? Now, they're also requiring the furniture to substantiate the accuracy and completeness of the information. Well, if they don't do that, well, okay. Delete or correct any information that cannot be fully verified. Well, guess what? You have to delete the information if it can't be fully verified. And you have to provide written notice of the results of your reinvestigation. Now, if they don't do any one of these 5, they have to address and update the account to benefit your reputation and credibility. If the accounts cannot be verified in compliance with the FCRA, they must be removed from my consumer file. Notice, this dispute is not an admission of liability and is submitted in good faith to ensure compliance with federal consumer protection law. Please respond within the time period prescribed by statute. Thank you for your prompt attention to this matter. Okay, so understand that even though it's not spiritual, it is spiritual. Okay, right now, negligence is the program. Distraction is the program. Let's center our focus to attention to action. Not the outcome of the action, just the attention to taking the right action. All right? So, thank you for your prompt attention to this matter. Boom, you're going to put your full name, remove the brackets, make sure your name is underlined for signature. And that S just means e-signature or digital signature that's approved by you. Okay, so bracket, lowercase s, bracket, or /s/. Enclosures, Exhibit A, a sworn declaration and affidavit under penalty of perjury, which we'll go over next. Exhibit B, Table 1.1 of accounts. Credit report entry with the account circled and a copy of your ID and proof of address. Now, just remember, I'm going to put this letter on pwashana.org so you will be able to download it and repurpose it for your own use. So why don't you go ahead and do that while I'm pulling up this next video or letter. Okay. This is your sworn declaration and affidavit under penalty of perjury, which um, is a very serious statement. Do not lie on this. Tell the truth. Be honest. Okay? Be as forthcoming as possible. And this is already designed for your forthcomingness. So if you agree with this, then use it. Sworn declaration and affidavit under penalty of perjury. I, put your name here, being a living natural person, hereby declare, state, and affirm the following to be true and correct based upon my personal knowledge, information, and belief. Declaration. I make this declaration voluntarily, in good faith, and under penalty of perjury, pursuant to the laws of the United States of America. This declaration is provided in support of my dispute of certain information appearing on my consumer credit reports. 2, statement of the facts. 1, non-acknowledgement of debt. As Pwashanan, we do not believe in debt. Okay, we do not believe that the universe created us to go into debt. So, although we owe money, we are not acknowledging a statutory debt. Why? Because our intention is always in good faith. We want to pay everybody. If there's money to pay you, if there's money to pay, we're paying. Okay, but we'll get to that in another. Most of you are in this situation, non-acknowledgement of the debt. I do not acknowledge the alleged accounts referenced in my credit report as legitimate, accurate, or enforceable debts owed by me. Any reporting of such accounts is disputed in their entirety. The accounts are listed on the enclosed table titled Table 1.1 Accounts. Okay, so we're not acknowledging this debt at all. And there's a reason for that, spiritually and consciously and in good faith. Okay, and that reason is very simple. When we entered the contract and we signed it, we did so ignorantly. You did not read all the fine print. You did not question them. You did not negotiate terms. You did not present anything other than your signature, okay? Which to them was an outright agreement that you read everything. And they can't say that you didn't because you said that you did. Now, 2, declaration of insolvency and inability to pay. At present, I am insolvent and do not possess the financial ability to satisfy alleged obligations without causing undue hardship. This statement is made solely for purposes of dispute, investigation, and consumer protection and shall not be construed as an admission of liability. So when you're insolvent, that means you don't have credit to pay your debts. Okay, either something happened, you lost your job, lack of income, something happened. You didn't just go from having money to not having money. You must articulate that. Okay? This is where we do that. Number 3, declaration of financial injury and impairment of constitutional rights. The continued reporting of the disputed accounts is causing ongoing and demonstrable financial injury, including impairment of my ability to secure housing, employment opportunities, credit access, and basic necessities, thereby interfering with my lawful rights to life, liberty, happiness, and property of which I am entitled to. Now, this is key, folks, because in Shana, Life, liberty, and happiness is the entitlement. Anything that infringes upon that is a statutory violation of Section 15 U.S.C. Section 1681. Okay, thus unfair. Number 4, unnecessary harmful reporting. The reporting of the disputed accounts lacks necessity, serves no legitimate consumer reporting purpose while disputed, and continues to cause harm that outweighs any claimed informational value. Now, what this means is that if you owe 10K, but then you can't get a $100,000 loan, well, it cost you 100,000 owing 10,000. So that is undue harm. And let's say you do put in an application for a loan from a company that would offer you 100K, and you specifically ask for 100K. Well, technically, anything that's on your credit that stops you from getting that loan has cost you that loan. Okay? If all other variables matched. All right? Meaning, if you had a plan to use the money correctly, if you had a plan to grow it and pay it back, this is all consideration you could have given to the lender had you not had these negative accounts on your consumer report. All right, so number 5, we are requesting a cease and desist request. I hereby request that all communications related to the disputed accounts cease and desist. Okay? Except as required to provide written verification, validation, or confirmation of deletion or permitted under applicable law. This means the only way they can call you is say they're going to delete it. If they call you beyond that, they have violated the cease and desist. You're basically saying they cannot communicate about this debt anymore. They cannot call you, and they won't call you. And if they do call you, they owe you money. It's like $1,000. Number 3, affidavit. Affidavit is basically your testimony. I affirm that the above statements are true and correct to the best of my knowledge and belief. I understand that knowingly making false statements under penalty of perjury may subject me to penalties under applicable law, executed on this day of the year, signed, signature. All right, written instructions to the credit reporting agencies. This is what we're telling them to do as part of our sworn declarations. Issued pursuant to the Fair Credit Reporting Act, 15 U.S.C., Section 1681. To whom it may concern, you are hereby provided notice of this sworn declaration and affidavit disputing the accuracy, completeness, and legitimacy of the referenced accounts. Pursuant to your obligations under the Fair Credit Reporting Act, you are instructed to conduct a reasonable reinvestigation of the disputed accounts, provide written notice of this sworn statement, dispute, declaration of injury, and cease and desist request to each furnisher of the disputed information, and require the furnisher to substantiate the accuracy and completeness of the reporting with competent evidence. Delete or correct any information that cannot be fully verified in compliance with FCRA requirements. 5, provide me with the results of your reinvestigation and, upon request, the method of verification used. This request is made in accordance with 15 U.S.C. Section 1681I and 1681S-2. And lastly, the notice, this declaration is not an admission of liability nor a refusal to cooperate with lawful investigation. It is a formal consumer dispute and sworn statement intended to invoke statutory protections and ensure accurate credit reporting. Matter of fact, I'm going to remove this word correct because we just want to delete it. All right, so let me save that. Boom. All right, now let's look at the table. The table is very simple. It is a copy of the creditor's name, the account number, and the reason for the dispute, inaccurate, incomplete, and unverified information. We just put that for all of them. And this will also be included on the website, and you will be able to get to the website here, I will show you. Boom. So on the site, I'll tell you where the letters will be located, but for now, the documents, you'll just scroll all the way down to where it says documents, and you'll see the documents listed in there. And I really appreciate you taking the time. It is the Church of Pwashana that offers this through Black Services Research and Development, which is our community-driven solution to provide practical applications in financial literacy, credit counseling, crisis intervention, housing assistance, food and nutrition, family, transportation, talent and contracts, inmate outreach and concierge, and much more. We will get to it, but take a look at our documents, and if you are in position to give to our mission, then you'll be able to do that in our benevolence link here. And I appreciate you all very much for taking time to be with me, and until next time. Now, the last thing is, if you are just pressed for time and you don't have the capacity to handle this process and would like for us to deal with it on your behalf, you can reach out, and I'll be more than happy to direct you access to our contract services, and we'll gladly perform the service on your behalf. And maybe your company can consider an in-kind donation, or we can service you under a retainer and a service agreement. So whichever way works best for you. We can definitely procure this in less than 7 days' time in most cases, if we're not on a waiting list. So please feel free to reach out and put your questions in the comments below if you want to engage in topic and Discord on this subject. And what you'll want to do, the last thing, is you really want to send this to each one of your creditors directly for the most impactful results. However, you can file this dispute online and or mail it into the credit bureaus, and the credit bureaus will forward it. It will take a little bit longer that way, but the other thing is you can call in and say these things over the phone. You can invoke these things over the phone. So if you want to call the creditor and notify them of these things, go ahead and do that, and then still send it in writing, and they'll have the documentation of that. And it doesn't matter what the account is, if it's open or closed, you can do this, but just understand that in good faith, if your situation, if you really lost your job and really don't have money to pay, then use the insolvency. But if you have the money to pay, then what we need to do is work out a payment schedule or allow us to negotiate on your behalf. And there are companies that do that as well. And we're a nonprofit that will extend our services in that way. So once again, Pwashana to you, which means protection to the oversoul. We give all praise to Uni. And Shana Mushir Jani, and look forward to seeing you again. Okay, I want to include this section for business owners. If you are running a credit repair company, what you need to do is adjust your company's framework to be consulting, business management consulting, under the umbrella of which you perform credit case management services by way of administrative assistance of dispute filing. Meaning, they're already going to file a dispute. You're not a credit repair company. You are a dispute filing company. And they are agreeing to file disputes under your methods. Okay? So that I suggest you follow that format. Okay? Because why? Because yes, we can address it just from the standpoint of your business. However, what's happening right now in the financial system is that cryptocurrency is now able to audit 100% of all financial records. Now, what does that mean? That means always over the table, always substantiate, always lawful. Okay? And this is going to protect your business. It's going to protect your future, and it's going to ensure that you operate in good faith no matter what's going on. All right, Inshallah.